All right. Hello, everyone. Thank you for tuning into this on-demand webinar on breaking down Brexit through the lens of HR and talent acquisition. Today, we're going to cover everything you need to know going into 2021. This session is being recorded in mid-December of 2020, hence the Christmas lights. And this session is intended to help guide you in your Brexit planning, even while final answers around a Brexit deal are still unclear. But we'll try to cover key dates, likely scenarios, and a broad overview of how you can prepare to recruit and retain post-Brexit. So quickly, some introductions. First, to introduce myself, I am Carolyn. I'm a member of the marketing team over at Workable, and a lot of my time in this role is spent making webinars and resources like this with talent acquisition professionals and HR professionals and business leaders, mostly people who are looking to grow their businesses. And I try to create spaces to discuss things like best practices, challenges in the industry, the future of the industry, and of course, Brexit has a huge impact on the recruitment and HR industry. So I am very pleased to be joined today by a great mind and Brexit expert, Stefan Nerinckx. Stefan, can you please give yourself a little introduction?
Hello, everyone. Hello, Carolyn. Thank you for the introduction. I am an employment law partner in the Brussels office of Fieldfisher. Fieldfisher being a European law firm being present in major cities in Europe. I have been dedicating these last 30 years now to the advice to companies, individuals on international mobility, focusing on immigration law, social security, and employment law.
Awesome. Great to have you here. And just moving on to the agenda to kind of get us started here. So basically, we've broken down this conversation to a few different pieces. Stefan will kick us off in just a bit around the current state of Brexit. And then we'll move into some really important topics like immigration, social security, employment law, and what we need to prioritize right now. And before we jump into that, just a quick disclaimer, this webinar is not legal counsel, but it is meant to be educational and beneficial. And while you'll definitely learn from Stefan today, for any decisions you or your organization make, just reach out to your internal legal teams. All right, so I think we can just jump right in now to the current state of Brexit. So Stefan, can you give us an update on where we're at right now?
Yes, Carolyn, as you know, we are in the final stage. We are in the final countdown to the end of the transition period, because as you know, we already had the withdrawal agreement. And now we are in that last phase, the transition period, ending at 11 p.m. on the 31st of December 2020. So as we speak, in the next few days, we are indeed ending that transition period. But as we speak also, we are still negotiating, the EU and the UK are still negotiating that trade deal. And although it's a very important deal, I think from a perspective of employment law, social security, or immigration, and if we look at other trade deals, well, they don't address a lot in respect of employment law, social security, or immigration. So I think we have to look and we have to follow it up and how these negotiations will end. But nevertheless, I think what we are going to talk about today will not be influenced largely to a deal or no deal on a trade agreement. As you see, so we are indeed in the last phase, and today we will focus on immigration, social security, and employment law, as you already mentioned. I wanted to share with you, to start with, the results of a survey conducted by the Vlerick School of Management, and they were investigating what the evolution in the future would be of international mobility, mainly influenced by COVID, but I think also from the Brexit perspective, we can learn something from this survey. the main conclusion you can take out of this survey is that short-term assignments will grow in the next few months, next few years, to the detriment of the long-term assignments. Why short-term? Well, certainly because of costs, because of people having fear to travel, so that's COVID related, but also what we see is a new trend in respect of international mobility being born. It is the blended assignment, how they call it. And that's the combination on the one hand of teleworking, so virtual working in one country, your home country, and then occasionally visiting another country, the host country, to control the project, how it will materialize, to troubleshoot. So the virtual teleworking combined with the business trip, or certainly the short-term assignment, so to speak.
Awesome. Thank you, Stefan. Great open, setting the stage. And I think the subject that makes the most sense to jump into next is immigration. And it's impossible to plan for Brexit without an understanding of how new immigration rules will impact recruitment plans. So a couple questions I'd love for you to cover in this section. First, how can employers organize themselves so they can continue recruiting candidates from outside of the UK with minimal disruption? Also, how can UK employers ensure their UK citizens seconded abroad can continue to work in the EU? And finally, what are the most immediate short-term steps employers need to take in order to ensure their staff can remain in the UK or UK citizens in the EU?
Yes, Karen, indeed. Questions I suspect a lot of companies are asking themselves. And to set the scene, I think we have to divide two periods, or to look at two periods. That is until the 31st of December 2020, and then as from the 1st of January 2021. And until the 31st of December, although there is the withdrawal agreement, UK left the EU, there is that transition period. And during the transition period, both UK citizens and citizens of the EU member states benefited of that free movement of persons, of workers. Very easy, you could go from the UK to France, to Belgium, you could work, you could reside without any, so to speak, boundaries or major boundaries. Now, this is going to change, obviously, as from the 1st of January 2021, because UK citizens will become third country nationals for the European member states, and European member state citizens will become third country nationals for the UK. So this is quite a very important shift. And what I certainly want to underline as from the beginning is that although we have the European Union, and although the European Union and immigration have edicted quite a number of legislation directives in respect of immigration, every single state has its own immigration legislation. So the legislation of those states is largely influenced by European legislation, but still it remains national legislation. That means that whenever you're going to send someone from the UK to France, you will have to look into French legislation. If you want then afterwards to send that person to Italy, you will have to look into Italian legislation on immigration. And this grid shows us that even in respect of Brexit, well, the national states are not all addressing, for instance, the Brexit with specific legislation. Some do, and some others don't. If we look at legislation in respect of the business trip, well, some national states or EU states have some legislation in respect of business trips, some others don't. The UK has been preparing itself very well in that sense that they have a specific legislation for the, I would say, EU nationals after the Brexit. And they have also been addressing the business trip legislation. So you see quite a variety of legislation, and even in respect of responding to Brexit, there is that variety and different legislation being put in place. For this part, I will divide the my presentation into two periods. That is that situations which are present before the 1st of January 2021, and then the ones who are new, who will start as from the 1st of January 2021. Because what is interesting is that in the withdrawal agreement, it is provided for that persons who are residing legally, working legally in the European Union before the 1st of January 2021, well, they can remain in that EU member state, they can reside legally, they can work legally in that EU member state. Of course, there again, every legislation and every national state will put in place which card will be delivered for the specific Brexit persons, UK nationals who were already entitled to reside and work on the EU member state. Secondly, indeed, the practical details will also be regulated by each member state. And if you go to our website, we have put together per state, in fact, the different legislation applicable for UK citizens being already entitled to reside and work in EU member states. So as long as this situation will take place, meaning that they will work, they will reside legally on the territory of an EU member state, as long as that situation will last, they will be able to reside legally and work on the Belgian territory, so on the EU member state territory. That means that if they are going to change work, employer, or they are going to interrupt their employment on an EU member state, at that stage, we start from zero and it's a new situation which will be addressed by different legislation. What is going to be considered as an interruption, what is going to be considered as a new situation is not yet clear in all the legislation of these EU member states. So this has still to be defined more in detail. For frontier workers, the same logic is working, meaning that whenever you work in one country, an EU member state, France, you live in the United Kingdom, and you go back to your home every single day, or eventually once a week or once a month, well, then you will be considered as a frontier worker. You will also still be able to do and to continue this situation after the 31st of December 2020. A special card will be delivered, specific legislation will determine the details. As such, someone using the Eurostar today, well, will continue to be able to do so even after the 31st of December 2020. But if something changes in the situation, new employer, new country, or putting the main residence on the EU territory, that are all elements which change the current situation, then it might have to be addressed as a new situation, new legislation being applicable. Again, the conditions of what is just to be considered as an interruption will have to be determined and is not yet clear state by state. Situations commencing on the 1st of January 2021, that's for the ones who, a UK citizen, starting a new employment in February 2021 on the territory of an EU member state. They will be considered as third country nationals, and as such, they will, to be able to work, have to comply with national legislation in respect of work permits. Eventually, as a self-employed, a card for self-employed, if the national legislation provides for that. You will probably have to demonstrate the added value, the commercial added value you will bring to that country, to that single country. The single permit application. In a few years ago, the European Union has been promulgating the single permit directive, implemented now by all states, meaning that it is a combined permit, work and residence, to be delivered by the national state authorities in respect of immigration. But of course, national regulation, national criteria, national thresholds. So in essence, There will be salary requirements, there will be requirements in respect of qualification. And if you don't comply with the salary requirements or the qualification, then probably you will have to investigate the labor market criterion. You will have to evidence to the authorities that you cannot find someone who is capable to exercise the same job on the territory of the European Union. So needless to say that it will be a difficult exercise to demonstrate this. That means also that low-skilled employees probably will have more difficulties in entering in the EU or the EU member states because the thresholds being high, qualifications, and being able or not being able to demonstrate that you cannot find someone on the EU territory, well, will bring to the result that that person will not be able to work on the territory of the EU member state. Besides the single permit, oh yes, one little detail, the government fees to apply for a single permit are quite low. And we will see later on that for the UK, these are quite high. So this is a major, I would say, difference, certainly in that respect. Business trips, again, national legislation will have to determine what is to be considered as a business trip, but it surely is not working as such. It's meetings in a closed circle, repairs, international transport, but not actually working. But it might be indeed, and there again, that blended assignment scenario, which was launched by that Vlerick survey, might come at hand, certainly to look into. The ICT permit, intra-company transfer, you send someone from the UK to France, that person has to perform a short-term assignment to Spain, for instance. Well, the French company will be able to apply for a ICT permit, very easy to obtain for that UK citizen to be able to work and to be assigned from France to Spain to exercise the work. Residents, there is a visa waiver program in place, that is sure. So UK citizens will be able to travel for 90 days to a European member state. But mind you, there is the ESTAS or the Limosa or other notifications that you will have to be making as a company for your employees entering the European Union. That is, whenever you enter a European member state, you will have to notify the authorities that you are entering. If there is a residence more than 90 days, a long-term visa, or eventually, if you're going to work, you will have to apply for that single permit. Let's have a look for people who indeed would like to work and reside in the United Kingdom. Again, also from a UK perspective, the end of free movement and the transition period ends the 31st of December 2020 at 11 p.m. A new immigration system has been put in place, but there is a specific immigration scheme for EU nationals who have already been working and residing in the UK. Still, that needs to be applied for. As we speak, this deadline is put at the 30th of June 2021, but I understand from my colleagues in the UK that this might be extended. But nevertheless, I think in those things that you better go for the quick approach and the immediate approach and don't wait for the deadline to approach. What is the situation for people who are already in the UK, so EU nationals who are presently in the UK before the 1st of January 2021? Well, they can apply for the EU pre-settlement scheme. What is the EU pre-settlement scheme? Well, they can continue like UK citizens in the EU. Well, EU citizens can continue to reside and to work in the UK if they have at least been 1 day in the last 6 months before the 31st of December 2020 in the United Kingdom. That permit will be valid for 5 years, and during the 5 years to come, they will be able to comply with the criteria to apply for the settlement status. And to get the settlement status, you have to be or work 5 years in the United Kingdom, and at least you have to spend a number of time, an important number of time in the UK to get that settlement status. For people who have been residing for 5 years in the UK prior to the 1st of January 2021, and it doesn't need to be in the last 5 years, it can be, for instance, from 2005 to 2010. Well, for those people, they can apply for the settlement status within the UK. What about the 1st of January or new situations starting as from the 1st of January 2021? Well, they will have to apply for a work permit. The sponsorship, and that means that businesses will have to require and will have to apply for a license. And to get that license, they will have to comply with a number of conditions. The company must show that it is a genuine organization. And the most tricky one is probably that the company needs to demonstrate that it is honest, dependable, and reliable. And I was told by my colleagues that it concerns the fact that companies should not have been convicted for criminal offense or for fraud, etc., by the UK courts or UK justice. The employee, on the other hand, will have to comply with, and to addition, a number of points. 70 points in total, but the 20 last points are flexible and could eventually be monitored. The 51st are linked to the knowledge of English, the skills the person has to comply with the job, the sponsorship of the company. The 20 last points will be considered or will be linked to the salary the employee is earning, the labor market criterion to be able to get the work permit delivered. So complex system, but nevertheless, certainly also being able, or certainly not, I would say, inachievable or not to be achieved. The license application for this process can take a long time within the United Kingdom, but moreover, what is interesting is indeed that the cost, only the government cost or the government fees to apply for that sponsorship might be between 8,000 to 10,000 British pounds per employee, obviously. So that is quite an interesting development for the application of the work permit in the United Kingdom. Other possibilities, as I was telling you, the business trips might be indeed interesting when we are talking about that blended assignment. Although I can suspect, and what I have been discussing with my colleagues in the United Kingdom, that this business trips definition is somewhat broader than in most European member states. Nevertheless, it does not concern actual work. It's activities which are to be performed in a closed circle, but which might also lead to coaching, for instance, troubleshooting, or even advice. So maybe a little bit larger as a definition than in most EU member states, but nevertheless, the UK Immigration Service can look into previous business trips the person has been performing, but also look into the nature and the scope of the business trip of the person going to the United Kingdom for the business trip. So certainly something to be very careful with in implementing or basing the employee immigration on the business trip scenario. The frontier worker permit, I am being told as we speak that there is legislation in the pipeline in the United Kingdom, but still under discussion. It would be a little bit more liberal also than most European schemes, in that sense that a return to the home for once every 6 months would be a possibility. So what are my tips? Well, first of all, in case you are being able to work and to reside in an EU member state or in the UK prior to the 1st of January 21, so actually today you have the entitlement to do so, register, do the necessary or take the necessary steps to be able to ensure the continuity of your residence and your work permit in those respective countries. Be in time in the applications, and also to complete your application, don't wait for the final deadlines. Be creative, and that's referring to that blended assignment, and anticipate any recruitment effort you would, for instance, like to start with in January. Maybe, probably you will already have started with it, but maybe then start before the 1st of January. It might be easier to find, not to find, but certainly to comply with the immigration obligations. And then think about the interaction with Social Security and employment law we are going to talk about in a second.
Great. Thank you again, Stefan. And next up, let's have a look at the topic of Social Security and Brexit. So what will Brexit mean for the social security rights of UK nationals, and what actions must employers take in order to comply with these changing laws and legislations?
Yes, indeed. Social Security is touching on private lives, of course, of the employee. It's also touching on the company's life in that sense that some formalities have to be complied with. And of course, it's also a cost-related issue because Social Security, employers' contributions have to be levied. And again, here, I would say that although we are talking sometimes about the United States of Europe, Europe is not the United States. Every single country has its own legislation in respect of Social Security. That means that the branches of Social Security might be different, the accumulation of periods might be different, the contributions to the Social Security scheme might be different. Now, what Europe has been trying to do, and very successful, is that they have tried to coordinate the systems within the European Union. So the different systems are being coordinated by regulations on a European level. That means that whenever someone is going from one country to another country, only one Social Security system will be applicable. So you cannot be confronted with a system where you have two systems of Social Security being applicable, or national systems of being applicable. You can be subject to the self-employed scheme or the salaried scheme, but you cannot be at the same time subject to Austrian Social Security and Belgian Social Security, so to speak. It's not a harmonization. Again, every single state has its own legislation in respect of Social Security. Now, what has been until the 31st of December 2020, nothing has changed. That means that the regulations still are applicable to UK citizens working in the EU and vice versa. What is going to happen, of course, is what is new as from the 1st of January 2021. Now, one thing here is that, again, not only the situation of countries or legislation in the countries is different, but also the interpretation will be different in respect of the withdrawal agreement and the obligations following the withdrawal agreement in respect of the interpretation regarding Social Security. So let's see, and I'm going to again to divide the presentation in two parts, because there is a situation which is present right now. So a situation which is actually going on. If the regulations did apply, you have been determining, or an employer has been determining which Social Security is applicable. The situation started before the 1st of January 2021. Well, at that moment, simply the situation will continue as if nothing changes after this 1st of January 2021. That means that whenever someone is being assigned, seconded from the UK to France, subject to UK Social Security, based on the EU regulation, well, that this person will continue to be subject to the UK Social Security scheme while working in France after the 1st of January 2021. But there again, as I mentioned, national states might differ from interpretation, and France and Germany, for instance, were very reluctant to continue to extend the validity of the secondment document, the so-called A1 document, which evidences that you are subject to the UK Social Security and that you should not be subject to the French Social Security scheme while being seconded. Well, France and Germany have decided to nevertheless extend, even if there is no deal, to extend those A1s as long as the situation of secondment continues after the 1st of January 2021. Italy, on the other hand, has decided not to extend those A1 documents if there is no deal. So you see, these interpretations can differ. And again, there we have to look into the national legislation to be able to see whether and to what extent and what the criteria are for employees, self-employed people being a subject or to the EU regulations at present, before the 31st of December 2020, well, that they can continue that situation after that date. The situation starting as from the 1st of January 2021, well, it's a new cross-border situation. So someone is being seconded 1st of February from the UK to the EU, or from one member state to the UK, or there is an interruption, meaning that someone who was seconded before the 31st of December 2020 to France, but then gets a new employment contract with the French company, well, there is an interruption, there is a new situation. Then, of course, the actual regulation being applicable might still be applicable, because it's also applicable to third country nationals, a UK citizens becoming a UK national, but the regulations might be different. Well, then it's the national legislation of every single member state which will be applicable. That means that, for instance, someone being assigned from the UK to France, let's assume there is no legislation, there is no treaty being signed. Well, that means that the person will be subject to the French Social Security. I will be coming back in a second with an example in that respect. So every national legislation becomes applicable. Every single national Social Security payments will also be applicable, and the accrual of rights. Meaning also that the accrual of rights will probably stop. I come back in a second to that. So whenever you are posting someone after the 1st of January 2021 from the EU to the UK, or from the UK to the EU, national legislation will be applicable. If you are posting someone from the EU to the UK, well, to be able to remain subject eventually to the national social security state of system of one of the member states, you will have to look into the national legislation. In Belgium, for instance, you can remain subject to the Belgium Social Security scheme, but up to 12 months maximum. Eventually, in the UK, where you are going to perform the work, UK authorities could claim Social Security contributions, but according to UK legislation, you can be exempt for 52 weeks. If you're posting someone from the UK to the EU, again, the EU member state legislation will be applicable of the territory where the employee will be working. If I take Belgium again as an example, well, you are subject to the Belgium Social Security if you are linked with a Belgian employer or linked with an establishment in Belgium of a foreign employer. If you're not, you can be exempt of Social Security, and this for an undetermined period as long as the situation lasts. You can, on the other hand, remain subject to the UK Social Security scheme for 52 weeks. But since you can be exempt in Belgium from the Social Security and for an undefined period, and only be covered for 52 weeks under the UK Social Security, you might end up after the 52 weeks to be not subject to any Social Security scheme at all. And then, of course, you will have to look into private schemes, other schemes of Social Security, to be able to protect your employee from a Social Security perspective. When we are talking about simultaneous employment, well, simultaneous employment, the regulation also addresses the possibility of a simultaneous employment and social security. There is no standard situation that I can put forward, and that would lead us way too far. There is no standard situation. It will depend on residence. It will depend on where the employer is being established. It will also depend on whether you work in your residence states, you don't work, and even to what extent you're going to work in your residence state. So there, we will have to look into it on a case-by-case basis to be able to determine what the social security scheme will be in a simultaneous employment situation. But you might have a situation where, in fact, someone, a UK national, is working in the UK, residing in Europe or in the European Union, and working also in the European Union in two different states, for instance, where the European regulation will regulate the social security aspects of all the activities being performed in the EU, but on the other hand, that the employee will also be subject to the UK Social Security for the activities performed in the UK. So there you might end up with a dual submission to Social Security. If we are talking about the coverage in respect of Social Security, I'm going to just focus on the aggregation of periods. That means that whenever you are working in one or in more states during your career in the European Union, this regulation I have been talking about also provides for the aggregation of periods of insurance. That means that whenever you have been working in different countries, your pension will be calculated according to a specific scheme, will be calculated taking into account all the periods of work you have been performing in EU member states. Well, of course, for situations existing before the 1st of January 2021 and continuing after the 31st of December 2020, well, for those situations, the accrual and the aggregation of the periods of coverage will continue. For persons where a new situation starts as from the 1st of January 2021, there we will, the national authorities will take into account the periods the person will have worked before the 1st of January 2021 in the different EU member states. But if a new situation starts, for instance, on the 1st of February 2021, well, as from that moment, situations or aggregations of periods will not be effectuated anymore because it's a new situation, and as such, this has been stopped on the 31st of December 2020. So quite some impact also in respect of coverage, pensions, unemployment benefits, health, disability might also have an influence on all these aspects. So what tips can I give to HR professionals in this respect? Well, if there is a cross-border situation right now, before the 31st of December, which is already pre-existing, apply for the A1 document, eventually certificate of E101 for third country nationals, just to be able to evidence to the authorities that the situation was already existing on the 31st of December 2020. And of course, for new situations, well, timely analyze the factual situation and determine time-wise and timely, of course, the applicable Social Security scheme, and of course, the application of the necessary documents to be able to evidence the Social Security status.
Thank you. I can't even begin to express just how complex this entire situation is and how complex it is for HR teams to coordinate through this. So thank you for breaking it down into as simple terms as possible. Yeah, I think that's great advice to kind of keep up with what are the facts, what do we see come through over the first few weeks, months of 21.
Yeah, and surely we have been confronted with schemes also, or with questions where people have different. The children live in one country, husband, spouse works in that country together with the children, but the other spouse works in another country. What about some people having the UK nationality, other ones having the EU nationality, married with someone, etc., etc. So it's quite interesting.
Next up, there is no question that Brexit will have substantial implications on employment law. We've kind of already gone around the subject in the last two sections, and it's still unclear as to the extent that this is going to be affected. But going into this section, definitely would love to have you cover like how are you currently advising HR teams when it comes to preparing for Brexit, and which legislation or legislations are the most probable to change in the next few months or year, and just generally, how can we prepare?
Yes, indeed. As you say, Karen, indeed, Brexit will also have an effect on the employment law and the evolution of employment law, both sides of the channel, I would say, in that sense that current legislation and probably in the near future and the short future, EU legislation which influenced UK legislation will probably continue to exist. I heard that a new body of retained EU law, so a law would be indeed adopted by which a number of legislation influenced by the European Union would be just taken over, continue to exist as such as it is. TUP, safety, certainly will be among that legislation. But of course, over time, the United Kingdom will be able to modify that legislation because they will be no longer held by what the European Union and by the legislation the European Union has been promulgating over the last decades. New legislation will certainly not be implemented, and even for directives of which the transposition would be after the 31st of 2020 will not be applicable in the United Kingdom. So we are talking about a whistleblower directive, which should be implemented in national legislation next year, the directive on work-life balance to reach male-female equality on the labor market. Another directive which should be implemented, the coronavirus work safety directive, well, we'll see whether that will be or not implemented even after Brexit. But as I said, new legislation will not be applicable. Also, the special situation of the European Works Council, which has an immediate impact, is not yet totally clear, as such that for the European Works Council, if you look at the legislation, well, it is so that whenever you have the headquarters in the country, that is that country legislation which will rule the constitution, the composition, the delegation of the representatives into the European Works Council. And if your European Works Council is established in the United Kingdom, well, as from the 1st of January 2021, that legislation probably will not be applicable anymore. So that's certainly something for companies who have, which have a European Works Council to look into. If you look at the UK legislation, and if I talk to my colleagues, then some legislation will certainly be affected by the Brexit, and UK authorities will develop their own legislation. Probably less protective, that's what we think. It's more because of probably certainly being very attractive also for foreign investors, etc. And the question, which is still not totally ruled out either, is whether the regulation or the court's decision of the European Court of Justice will be respected by the British courts after the 31st of December 2020. As such, a lot of legislation promulgated by EU has been interpreted by the European Court of Justice. There is quite some abundant case law, and the question is whether that case law will still be taken into account by British courts, which is the case and which is an obligation, of course, if you are part of the EU, because the European Court of Justice being the highest court in the European Union. What areas might have or might be impacted? Transfer of undertaking directive, dismissal protection, probably. If you have a transfer of undertaking, there is a dismissal protection for employees being taken over. There is a general principle not to dismiss the employees taken over because of the transfer. That might be indeed, I would say, that protection might be lowered. There is an obligation of harmonization after a certain extent, and certainly to take over the existing working regulations, working conditions. That might also be altered. Working time, 48 hours on a weekly basis is the maximum on a European level. It might be higher in the new United Kingdom, I would so to speak. Interim workers' protection might be less. Anyway, I think there might certainly be some changes, and over time, legislation will indeed diverge and will be going more separate from what is going to be done in the European Union. What is also equally important is indeed in the relations and in the international mobility between the United Kingdom and the European Union. As there is for the social security, there is also for the law being applicable to contracts, and more precisely to employment contracts. There exists also a regulation. That regulation is determining the legislation applicable whenever people work in different countries. Employer is in one country, the employee works in another country, or eventually in a case of being seconded. That Rome I regulation, as it is called, is by the act of the 29th of March 2019 being taken over. It's international private law and is being taken over in the United Kingdom as such as we speak. But future changes might be expected because it is now a national legislation. It's not a European law anymore, so to speak. It's not a European regulation, so to speak, not anymore. So indeed, it becomes a national legislation, and a national legislation can be adapted by the national legislator, which is not the case in the European Union because the regulation is a supranational source of law. Some particularities also about the posting directive. The posting directive, implemented in national legislation, provides for a minimum standard of legislation being applicable as from the first day of employment on the territory of that state, whatever member state that is. Also, particularly in that posting directive, is that the courts of the country where the person is being posted are competent to take into account and to rule over a litigation case which has been brought to that national court. So that's also a specific rule of competence of courts. The question is what is going to happen with that perspective or that regulation. Well, let's just have a look at how that Rome I regulation works and how it will affect the law applicable to employment contracts in a cross-channel mobility scenario. First of all, the Rome I provides that parties can choose the law applicable to the employment contract. But if that has not been done, then the country of habitual employment will rule the employment contract. Or if that is failing and you are working in different countries, it is where the employee is being hired, so the employer's place. Or eventually, if there is a closer connection with any other territory the employee has or is performing work. If the choice of law is being made, even then the parties have the obligation to look into what the normal legislation would be if no choice would have been made. Meaning that even if a choice is being made, well, even in that case, the judge will have to look into the country of habitual and performance. He will have to determine the country of habitual performance, and he will have to check whether the legislation of an imperative kind of that national country is not more protective than the legislation chosen by the parties. If it is, he will have to apply the legislation of the country of habitual performance, habitual employment. And that goes for the other regulations or or rules, in fact, to determine the applicable legislation. So even, in fact, for a secondment, if someone is seconded, well, in that case, the employment legislation of the home country will continue to be applied. It's the place of habitual employment, but the Rome 1 specifies that this can remain applicable in case the employee is returning to the home country. So there is a return and there is a close link still with the home country. Otherwise, the legislation of habitual employment of the host country might become applicable. So quite an interesting way of determining what law will be applicable. So let's have a look on what will this have as a consequence after the Brexit. I took here a Belgian perspective, but this is certainly can be applied for other countries of the European Union. If someone is a permanent employee being sent from the United Kingdom to Belgium to become a permanent employee, having a contract, an employment contract with a Belgian entity, well, it will be, of course, Belgian legislation being applicable. But of course, if you have specific clauses which determine that it is applicable in the whole of the EU, for instance, a non-compete clause, if that clause mentions EU, you might have to adapt that clause because the UK is no longer part of the EU, and so you might have to adapt the clause to say EU and the UK. If we look at the posting example, well, if an employment contract is concluded before the 31st of December 2020, the Rome regulation, the Rome 1 regulation I was explaining will be applying. So from Belgium to the UK, someone is being seconded, posted to the United Kingdom. That employee is returning to Belgium at the end of his posting. It's provided for, the link continues to exist between the employer and the employee. Well, as such, Belgian legislation will remain applicable because there is a return provided for. That would be different if there would be no return, but let's assume there is that return. So eventually, some legislation of the United Kingdom will become applicable because the fact of that posting directive stating that as from the first day of employment on the United Kingdom, some legislation will be applicable. If the contract is concluded after the 1st of January 2021, well, let's assume the Rome 1 rules will not apply anymore in the future. Then, of course, the legislation that you have been applied to, that has been applied to the employment contract, stating the Belgian legislation, because that's the legislation of the habitual employment, which could continue to be applicable even during the posting, during the secondment, because the country of habitual employment remains Belgium. Well, in this case, when the Rome 1 regulation is not going to be applied anymore, it might that all UK legislation becomes applicable and that no longer the Belgian legislation is applicable on the employment contract, meaning that a judge being confronted in the United Kingdom with litigation in respect of an employment contract might decide that UK legislation is applicable. And if the judge analyzes the employment contract and states that, or comes to the conclusion that those clauses are absolutely not in line with UK legislation, that they are unenforceable, even to a certain extent void, would mean that the clause and the employment contract would not be enforceable towards the employee. And as such, that you will end up with, well, a less protective employment contract at the end. So in that case, it might be useful to adapt the addendum or the employment contract to be able to comply with the UK legislation and eventually the Belgian legislation if it can be brought together, or both legislation can be brought together.
Wow. Again, so much gray area, so much going on with employment law. But thank you for breaking it down as much as we can right now. It definitely is unique, case by case basis, but this definitely helps clear up a really complicated subject. And same goes for immigration, Social Security, each piece of this conversation. Thank you for breaking down what's actually happening right now. That pretty much brings us to the end of our conversation. I do have one more question for you to help advise recruiters and HR teams and business leaders on what to do next. But I did want to quickly give Workable a shout out. If you don't already know, Workable provides best-in-class recruitment tools, processes, and automation in one complete system. We have amazing customer service and more than 20,000 customers all over the world. So definitely feel free to check us out and let us know if you'd like to learn more.
For your comments. Yes, it is a complex situation, and it is also even more complex because some of those items are not yet clear. Like, for instance, what is going to be the evolution of employment law? What is going to change? To what extent it is going to change? Is the European Court still having authority? Or are in effect the English courts, the UK courts, going to continue to apply what the European Court has been ruling in the last few years? So all these things remain, of course, to be answered, and that is certainly the last part is probably the most uncertain part, how it is going to evolve in the next future. As for immigration and social security, the withdrawal agreement made it clear that there is a situation before the 1st of January 2021 and as from the 1st of January 2021. And so that's where, of course, companies, legal counsel have to be very aware of certainly on immigration, social security, to be putting in place what needs to be put in place, registration, to warn their employees to do necessary steps towards the authorities. And then on the other hand, to follow very closely the evolution of where, in fact, that legislation is going to go. And as from the 1st of January 2021, whenever there is a cross-border mobility of workers, then I would say we, from both ends, we will have to look at the situation from a third country national perspective and not anymore from a free movement, free worker, from an EU citizen perspective.
Definitely. Yeah. And I'd say probably the last question I'll leave you with is, after business leaders, HR teams, all of us kind of adapt to these laws and figure this out, when do you expect that we'll reach a new normal? And when will the dust settle and we'll kind of just be adapted post-Brexit?
Yeah, I think that certainly for immigration and for social security, I think there it is quite clear already. But even there will be evolutions, because there might be, even in the trade agreement, still some particularities in respect of social security coverage, or applying nevertheless the regulation even in a UK EU perspective. There might also in the future be bilateral agreements being concluded between EU countries and the UK, for instance. So I think it's difficult to say when there will be that new normal, as you say. I think this will evolve. It is a new era we are going to enter into, and of course the transition period has made us aware of the differences and of what we have to take into account whenever we structure strategically international mobility scenarios. But it is going to be evolving all the time, I think, and it's yeah, we will have to be following up all the evolutions very
Mhm.
closely in next few years, decades probably.
Yep. Interesting stuff. But thank you so much again for all your help putting all this awesome information together. I know it's going to help us. It's going to help a lot of people out there. And yeah, we'll keep an eye on the situation and keep chugging forward. But thank you again so much, Stefan, for your time.
Thank you very much.